Heard Mr. C.D. Runsang, learned counsel for the applicant. Also heard Ms.
Mr. Z. Kulnu.
Mr. Z.
Kulnu.
Kulnu, learned counsel for respondent number.
One. Oh, for the this one. Yes, your
Lordship, the appellant. I am the applicant in the IA, and I am the respondent number 2 and 3.
Okay.
The appeal.
Learned counsel for the appellant / opposite party in the IA, who prays for
2 weeks.
2 weeks time for filing
The affidavit in opposition.
the affidavit in opposition. Also,
I'm for the claimant, Lord. So Foseco.
Mr. Foseco Forte, learned counsel for the claimant. The prayer is allowed. Let this matter be listed after 2 weeks.
Much obliged, sir.
May I
Okay,
proceed? Lordship, I beg to mention item 33. 33, I'm for the respondent number 2, Lordship. Respondent number 2. Lordship, today my senior has some difficulties with the matter can come up after 2 weeks, Lordship.
Who is for the petitioner?
I'm for the petitioner, Your Lordship. Lordship, can it be listed on 27 of this month?
Okay. Heard Ms. Tuyek Rulu, learned counsel for the petitioner. Also heard Mr. Foseco Forte, learned counsel for respondent number 2.
Two, Lordship.
Prays for an adjournment on the ground of personal difficulty of the conducting counsel for the respondent. The prayer is allowed. Let this matter be listed again on 27th of March.
Lordship.
Lordship, there's the interim may continue.
The interim order shall come. Yes, what is your prayer?
Lordship, we are yet to file our vakalat nama and objection, so kindly grant 4 weeks time.
You are for respondent.
No, yes. For respondent number 1 and 2.
Lordship, I am appealing for the appellant.
Mr. What is your name?
Tayon Chuba, on behalf of Ben Sharma.
Heard Ms. Tayan Chuba, learned counsel appearing on behalf of Mr. B.N. Sharma, learned counsel for the appeal. Also heard Ms. Tuyek Rulu, who submits that they are engaged by the respondent side and will be filing their vakalat nama,
An objection, Your Lordship.
and as well as written objection for which some time is prayed for. The prayer is allowed. How much? time?
Lordship,
4 weeks.
Lordship, since it is in the hearing stage and the appellant will not be filing any reply to the objection, so it may be heard on the same day.
Let this matter be listed after
4 weeks.
4 weeks.
Let's-
Obliged.
May I please, Your Lordship? Lordship, I'd like to mention hearing item 30.
38.
Yes, Lordship, on this matter, I'm awaiting instruction from the petitioners.
For
The petitioners, Lordship. So kindly grant me 2 weeks.
30, what's your name?
Nitya Koza, Lordship.
Heard Ms. Nite Koza, learned counsel for the
Petitioners.
petitioners, who submits that she needs some instructions from the petitioner side, for which some time is prayed for.
Lordship.
Also heard Mr.
LD Sankan, additional AG. For state respondent number 3, 4, and 5.
learned additional AG, appearing for respondent number
3, 4, and 5.
3, 4, and 5, as well as
Rosemary Kikon appearing respondent number 2 and 3.
appearing for respondent number 2 and 3. The prayer is allowed. Let this matter be listed after
2 weeks,
2
Lordship.
weeks.
My lord, I'm for R4, 5, and 6, Your Lordship. Sorry.
Mr. Sankam, respondent number 4, 5, 5, and 6. Okay.
Obliged,
Filed
Lordship.
as directed by this honorable court, order dated 13/5/2024. I have filed my additional affidavit also.
That is on record.
Yes, my lord.
Okay.
Much obliged.
Oh, please, Your Lordship. May we please to mention item 2, 3, and 4, Your Lordship. Here I am directed to file additional affidavit, Your Lordship. Your Lordship, so another 3 weeks will be granted to me, Your Lordship. Affidavit already filed, Your Lordship. There's an additional affidavit to be filed, Your Lordship. On the last date of hearing, Your Lordship, I was instructed to file an additional affidavit.
And this is a very old pending.
Yes, Your Lordship. That's why, Your Lord, we took up the matter on the last date, Your Lordship. Meantime, there were some instruction that I need to place, Your Lordship. Therefore, this honorable court directed the state government to file additional affidavit, Your Lordship. So I may be allowed another 3 weeks so that I could
Okay.
incorporate all the instruction.
Heard Ms. Livika,
Yes, Your Lordship.
learned additional,
No, Your Lordship, government advocate, Your Lordship.
learned government advocate, Nagaland, who prays for 3 weeks time for filing additional affidavit, which was directed to be filed by the government responding by earlier orders of this court. Also heard Ms. Lucino, you are not objecting,
No, my lord, I.
who does not have any objection to the prayer made by the council for learned government council, hence the prayer is allowed. Let this matter be listed after 3 weeks.
Much obliged.
May it please your lordship. Lordship, I'd like to mention hearing item 31. 3-1. I'm
Yes.
representing the state here. Lordship, this matter will cover after 2 weeks.
I have no objections, Lordship.
Third, Mr. Muaz Zamir, learned senior government advocate, who prays for, why
weeks,
you are praying?
2 weeks time.
What is the ground?
Lordship, I'm seeking some extra instruction.
Who prays
Some
for
clarification.
2 weeks time for seeking some instructions relevant for this instant case. Also, Mr. Senti Younger, learned counsel for the petitioner, who does not oppose the prayer. Hence, the prayer is allowed. Let this matter be listed after 2 weeks.
2 weeks.
I appeal respondent 427.
What's your name?
Okay, Richard Omanor.
Show his presence. Respondent number 42427.
Okay, sure.
Lordship, I may be allowed to make a mention for item 9, the contempt petition, Lordship. Here I have received the affidavit in opposition filed by the respondents this morning inside the courtroom only, Lordship. So I may kindly be granted 2 weeks to kindly peruse it and file reply if required.
But Mr. Senti Younger, learned counsel for the petitioner. You are appearing. Who is appearing?
Correspondent number 3. I
Heard
will
that.
file my contract.
Also, heard Mr. Muaz Zamir, learned senior government counsel appearing for respondent number 3. Learned counsel for the petitioner submits that he has received the copy of affidavit in opposition today only, and therefore he prays for.
Filed by the respondent number 3.
Filed by the respondent number 3, and therefore he prays for some time to go through it and to file affidavit in reply if required.
My lord,
The prayer is allowed. Let this matter be listed after 3 weeks.
deeply obliged.
Lordship, I am for respondent number 2.
Mr. V. Zimomi appear for
Respondent number 2.
respondent number 2.
May I please, your lordship? Lordship, I beg to mention item number 17.
Item number?
17.
Yes.
Lordship, I represent the respondent number 9 and 10. And now I have to file a complaints affidavit on behalf of.
But why your name is not shown in the cause list?
Yes. It has to be shown. I am for the respondent number 9 and 10. So,
What is your prayer?
Lordship, here, respondent number 9, 10 is already filed. So I have received an instruction from the respondent number 9. So I need 1 week time to file a complaints affidavit. So this matter may be listed after a week.
Compliance affidavit. It
Complaints.
has been complied. Order has
Yes,
been
I have to file an affidavit in the form of affidavit. Yes.
heard Mr. Supongwati Waling. You have no objection.
No objection.
Also heard Mr. Imti Imsong, learned counsel for respondent number 10, 9 and 10, who seeks some more time for filing an affidavit in compliance by respondent number
9.
9 in this case. The prayer is allowed. How much time?
After a week. Listed on 27th of March,
Let this matter be listed again on
27th.
27th of March.
Lordship, I have one more item, item number 21, hearing item. Lordship, here I am for the state respondent, and the appellant is coming from all day from Gauhati. And regarding to the learned law report, additional evidence and finding out the learned law report, we received only last week. So the party, we have discussed that this matter will be listed on 20th of April.
You have informed the
Yes, I have taken the counsel of the senior counsel.
Mr. MT Imsong Learned. You are additional AG,
Lordship,
additional advocate general, who prays for an adjournment. He also submits that he has informed the counsel for the appellant regarding his prayer for adjournment. And suggests and both the parties have agreed to that this matter may be fixed on
28th April.
28th of April. The prayer is allowed, list accordingly.
Yeah, please, Your Lordship. I beg to mention item 24 from the hearing list, Your Lordship. This matter may kindly be listed after 2 weeks, Your Lordship.
Lordship, let this matter come up on 27th of March next week.
Your Lordship, though I have some difficulty, but I can make an endeavor.
On 27th.
Yes, Your Lordship.
If you have difficulty, let it come after 2 weeks.
After 2 weeks, Your Lordship. I
Yes,
prefer
heard
after 2
Miss,
weeks.
what's your name?
Inaholi, Your Lordship.
Heard Miss Inahali, Learned. Mr. Mozui, you are also appearing,
Yes, for respondent number 8, Lordship.
and you are for respondent number?
All the states respondents, Your Lordship. 1 to
Learned
7. Your
Government
Lordship.
Council appearing for all the state respondent. Also at N Mozui, Learned Council for respondent number 8. Also heard Miss
Ubang Nan La Longcha for the petitioner.
Night only. Learned Government Council seeks 2 weeks' time due to some personal difficulties. The prayer is allowed. Let this matter be listed after 2 weeks.
Much obliged, Your Lordship.
Lordship, I beg to mention item number 22 and 23. Lordship, here we received the inquiry report only on the last date. So we wish to file an additional affidavit. Can you grant us 3 weeks?
You are for?
I'm for the petition, Lordship, in both items.
What is your name?
Ubang Nan La Longcha. My name is not in the cause list, Lordship.
Okay. You have informed the other side.
Lordship.
Heard Miss Right hand. Learned Counsel for the petitioner, also heard Miss Livika, Learned Government Counsel. The counsel for petitioner submits that they have received the affidavit in opposition.
Lordship, not affidavit. We have received the inquiry report
Inquiry report
Yes.
today only.
on the last date. That was 2 weeks ago, Lordship.
On the last date and needs some more time to go through it
And to file an additional affidavit.
and to file an additional affidavit. Learned Government Council does not opposes the prayer. Hence the prayer is allowed. Let this matter be listed after 2 weeks.
Obliged, Lordship. Lordship, I beg to mention item number 32 also. Lordship, here there is a connected item. There's a connected matter which is reserved for judgment.
Okay, then
That is WPC 212 of 2022. So this, yes, Lordship, let this come up after the judgment.
heard Miss
Obang Nan La Longcha.
Obang
Obang Nan La Longcha.
Bang Lel Na Longcha.
Longcha.
Learned Counsel for the petitioner. Who is appearing for the Also heard Mr.
Gauhati, CGC.
Yangarwati, Learned Central Government Council. Learned Council for the petitioner has submitted that a connected matter, that is writ petition number 212/2022 is fixed for delivery of judgment, has been reserved for delivery of judgment.
Yes,
And
Lordship.
she prays that this matter being connected to this said matter be taken up only after delivery of the judgment. The prayer is allowed. Let this matter be listed after delivery of the judgment in the case of WPC number 212/2022.
Yes.
Obliged, Lordship.
Maybe less Lordship. Lordship, I beg to mention item number 14 on behalf of Mr. Zeran Muli, CGC. This matter can be listed after 2 weeks.
You have informed the petitioner.
Yes. I have no objections, Lordship.
Heard Mr. Yangarwati, Learned Central Government Standing Council, who prays for an adjournment for 2 weeks. Also heard Mr. Senti Younger, Learned Counsel for the petitioner, who does not opposes the prayer. The prayer is allowed. List this matter after 2 weeks.
Lordship, there is an interim.
The interim order shall continue till next day.
Much obliged, Madam. Lordship, I also beg to mention item number 8. On the last occasion, I was instructed to appear on this on behalf of the Union of India, and I have not received any instructions. So I may be given another for 3 weeks' time.
Your Lordship, if I may respectfully state, it appears the union is not interested. Last year, the notice was once completed, but since they did not appear, this Honorable Court again directed us to serve through dusty service. The same was also done. Now, Your Lordship, on the last occasion also, it was on the insistence of this Honorable Court that my learned friend, my senior colleague, Mr. Yangarwati, has been made to appear. Even now also, they're not appearing, Your Lordship. It appears only personal appearance would be fitting, Your Lordship, because this is only for the appointment of an arbitrator. And this petition has been kept pending for a very long time, Your Lordship.
There is an agreement, arbitration agreement.
Yes, Your Lordship.
And this is an application under 11(6).
Yes, my Lord.
Last chances.
So what is the object? What you are objecting to appointment?
Lordship, I have not received any instruction.
No, this matter after issuance of notice, there is a time limit.
There's a last chance, Lordship.
For what?
For further instruction.
54 matter. Yes, Mr. Sheki.
My Lord,
You have proposed some name.
no, Your Lordship. We actually we are requesting this Honorable Court to appoint a neutral arbitrator for both the parties. In fact, we have suggested for the name of Justice. We have proposed a name, Your Lordship. We have proposed the name which, Your Lordship, is part of the petition, Your Lordship.
Whose name?
Justice. Sarma. My Lord, my sincere apologies, Your Lordship.
Mr. Yangarwati, you take instructions whether you have any objection regarding
Yes, sir.
appointment of the person whose name is being proposed.
Well.
Mr. Angami, you are also there.
Yes, Your Lordship, I am for the respondent number 2, Your Lordship. In fact, Your Lordship state has a very limited role to play for the fact that now the contract has been cancelled by the Union of India. The contract has already been cancelled.
As far as the role is concerned, Your Lordship, both the state as well as the union are severally liable, Your Lordship.
Okay, heard
Jointly
Mr.
and severally
heard
liable.
Mr. Joshua Sheki, Learned Counsel for the petitioner. Also heard Mr. Yangarwati, Learned Central Government Standing Council.
That's Standing, Lordship. Central Government Council.
Central Government Council, as well as Mr. N. Angami, Learned Senior Government Council,
For respondent number
appearing for respondent number
2.
to Learned Central Government Council seeks some time for taking instructions in this matter. What should we do?
My lord,
We
I
are
beg,
giving one chance.
if not, my lord, this has been pending for a very long time. So perhaps a personal appearance would be more befitting, your lordship, because on the earlier occasion, notice was completed, and it is in the
Whose
record
name
of the
has been
zoning court.
proposed? Whose name has been proposed?
Lordship,
It appears from record
my lord,
that
I'll find out, your lordship.
one
it's here.
name has been proposed to be appointed as
BK
arbitrator.
Sharma, your lordship.
Name of Justice within bracket retired BK Sharma has been proposed as to be appointed as arbitrator. Mr. Yangarvati Lanet Central Government Council shall take instructions regarding the said name.
Lordship, if I am not mistaken, the High Court, Honorable High Court has prepared a list of,
Panel is there.
yes, a panel,
From that panel,
whether his name appears in that panel or not. That's
We have no
what-
issue, your lordship, as far as the,
so you take
as long as the
instruction
appointment
with-
is made, your lordship.
That can be found out through the registry, Lordship. The list of panels that has been recommended by
No,
the.
we will appoint, but after hearing what you have to say in this regard, you take instructions.
Madam.
Lord, it may kindly be noted in the order that on the earlier occasion, notice was already completed, but re-notice in the manner of a dusty service was again served.
No, now
But
he
they
has
not showing
appeared.
interest.
Now he has appeared.
That on the insistence of the honorable court, not on the instruction of the respondent, your lordship.
Yes, Lordship. On the instruction of the court, I am agreeing.
No, but
So
he,
I mean, given the last chance for 3 weeks.
Learned Central Government Council seeks 3 weeks time for getting instructions. Considering the nature of case, the prayer is allowed as a last opportunity to the learned Central Government Council to take instruction in this regard, list accordingly.
Your lordship, if no instruction is forthcoming on the next date, because already 4 weeks have
That we
lapsed, my
will
lord,
consider
then
on the
personal
next date.
appearance, your lordship. My lord. Oblige, your lordship.
My lord, please allow me to mention here item 34. I'm for respondent. The matter may be fixed after a week. Hearing item 34.
Heard Mr. Yangarvati, learned counsel for the appellant. Also heard Mr.
Kinritsawo.
Learned Pakinri Chabo, learned counsel for the respondent, who seeks 2 weeks time,
Only 1 week, my lord. Only 1
1
week
week time
yeah.
for
hearing, my lord. And my lord, my
who
name.
seeks 1 week time for 1 week adjournment due to personal difficulty. Stop. It appears that name of the counsel for the respondent is not reflected in the cause list. The registry is directed to reflect the name of Mr. Pakinri Chapo as engaged counsel for respondent number 2 in the cause list henceforth.
Yes, my lord.
List accordingly.
My lord, and the name of the learned counsel, P. Suren, may also be reflected.
As well as Mr. P.
Suren.
Suren.
Peace, Your Lordship. Lordship, I'd like to mention items 6 and 7, Lordship, on behalf of my colleague, Lordship. If 2 weeks' time is granted to file my affidavit in opposition, Lordship.
What is your name?
S. Chang,
Heard Miss S. Chan submitting on behalf of
M. Nongkumar.
Mr. N. Longkumar, learned counsel for the respondent. Also heard Mr. S. Walling, learned counsel for the petitioner. learned counsel for the respondent seeks
2 weeks.
2 weeks time for filing affidavit in opposition. The counsel for petitioner does not opposes the prayer, hence the prayer is allowed. What is your name?
And approved. Correspondence number 5 to 16.
Show the presence of Ms. N. Rupuru for respondent number 5 to 16. The prayer is allowed.
My pleasure, Lordship, I beg to mention item 36. If this matter can be listed on 24th. For the petitioner, Your Lordship.
What is your name?
Kate Secretary, Lordship.
Case. Heard Ms. Case Kuru, learned counsel for the petitioner. Also heard Ms. S. Chang, learned counsel for the state respondent,
One. Two. I'm for respondent 1.
as well as Ms.
Menashino.
being for respondent number Menoshino, learned counsel for respondent number 1. Learned counsel for the petitioner prays for an adjournment. On what ground?
The leading counsel has some difficulty today, Lordship.
Due to personal difficulty of the conducting counsel for the petitioner. Considering the ground, the prayer is allowed. Let this matter be listed on
24th.
of March.
Yes, Lordship. Interim may be extended.
The interim order shall continue till next week.
Obliged, Lordship.
Please, Your Lordship. Lordship, I beg to mention item number 10, Your Lordship. Here I'm appearing for the sole respondent. Here we are yet to file our affidavit in opposition, Your Lordship. So if 2 weeks may be granted, Your Lordship.
What is the matter?
My lord, I'm challenging the family court order, the Dimapur family court order.
Heard Mr. Pakindri Chapo, learned counsel for the petitioner, as well as M. Vero, learned counsel for the respondent, who prays for some time for filing a written objection against the revision petition filed by the petitioner. The prayer is allowed. Let this matter be listed after
2 weeks, Lordship.
2 weeks.
Okay. Much obliged, Your Lordship.
Lordship, I would like to mention item number 29 from the hearing list. May kindly pass over the matter for the day, Lordship. I've taken the consent from the opposite party.
You are Moa Jamil.
Lordship.
The earlier one was Moa Imchen.
Lordship.
Okay. We have to make some corrections. Yes, what is the prayer?
If the matter can be taken up tomorrow, Lordship, possible for the day, Lordship.
Yes, what's agreed? Heard Mr. Moaz Amir, learned counsel for the petitioner, who prays for listing this matter tomorrow, that is on 18th of March. The learned counsel for the respondent does not opposes the prayer. Hence, the prayer is allowed. Let this matter be listed tomorrow.
Much obliged.
For motion, item number 1.
My pleasure, Your Lordship. Your Lordship, at this particular is string file for the employment of the new respondent. That is respondent number 4, that is Shiri Muhammad Ali Shiab. I is Commissioner Secretary P near department as respondent number 4. Since the earlier respondent number 1 in the main contempt petition is no longer holding the post. So for this reason, I filed the present I for implement of the new incumbent.
Heard Mr. Supongwati Waling, learned counsel for the applicant. This application has been filed by the petitioner for impleadment of Shri Muhammad Ali Shihab, new incumbent to the post of Commissioner and Secretary, PA and AR Department, Nagaland, Kohima, as respondent number 4 in the civil original petition within bracket C number 19/2024. Learned counsel for the petitioner has submitted that the petitioner has filed a civil original contempt petition number 19/25
24, Lordship.
24, wherein it has been alleged that the order of this court, which was passed on 26/9/2023 in WPC 187/2024, has not been complied with by the respondents. In the contempt petition, the respondent number 1 has been named as Shri Anup Kinchi, who was the then Commissioner and Secretary to the Government of Nagaland, PNR and AR Department. Learned counsel for the petitioner submits that Mr. Kinchi has been transferred from the said post, and the Shri Muhammad Ali Sahib has joined as the new Commissioner and Secretary, Personnel and Administrative Reforms Department, Kohima, and it has become necessary to implead him as respondent number 4 in the original contempt petition. Considering the grounds taken and submissions made by learned counsel for the petitioner, the prayer is allowed. This interlocutory application is disposed of with a direction to implead Mr. Muhammad Ali Shihab, IAS, the present incumbent, the incumbent Commissioner and Secretary, Personnel and Administrative Reforms Department, Nagaland, as respondent number 4 in the civil original within bracket contempt petition number 4 of
19 of 2024.
19, number 19 of 2024. This interlocutory application is disposed of. The petitioner shall file the amended cause title in the connected civil original petition within bracket C 19/2024.
And then I may be allowed to take steps upon respondent
No,
3 and 4
After
findings.
after the said matter would be listed after filing of the amended cause title by the petitioner after a week.
Lordship. Obliged.
For admission, item number 5.
Mr. Lordship. Here, the present civil revision is been filed by the petitioner, where he is aggrieved by the impugned order passed by land dispute settlement report passed by the head to Bashi, customary court Oka. And then where half portion of my land was given to the bribery respondent 4 and 5
Half portion
of my land.
Okay.
And then after that, the deputy commissioner is then directed me to vacate the place, for which I have the petitions before this honorable court.
Who is appearing? Mr. Zimomi, you are appearing for the other side.
I'm for respondent number 1 to 3, Lordship.
It can be heard today for disposal.
Lordship.
Okay. What is the matter? Now you tell me.
Yes, Lordship. Your Lordship here, before that, Your Lordship, respondent 4 and 5, Your Lordship, several steps has been taken on 9/9/2022, Your Lordship, where I was directed to file by way of trustee. Then accordingly, I filed my affidavit on 9/9/2022.
Notice is complete.
Yes, Lordship.
Who are respondent number 4 and 5?
Your Lordship, respondent number 4 and 5, they are private respondents, where, as I've said earlier, half portion of money was given to just respondent number 4 and 5. And then not only trustee, but in Your Lordship, again, I was directed to publish on a local tea list.
So the notice has been deemed to be duly served.
Yes, Lordship.
Where is the order?
Your Lordship, the earlier order is on 9th of September 2022. That is regarding the trustee service. 9 September 2022.
Now thereafter, where is the order where the notice?
On that also on 19/9/2024. 19/9/2024. 19 September 2024.
No, that was a direction for issuing subsidy.
Lordship.
Sales by substitute.
Lordship.
Whether the notice has been duly served or not. Is there any order of the court?
Your Lordship, on 18/10/2024. That was 18th of October 2024.
Okay.
That is-
18 notice was duly served.
That's Lordship. That is the last order.
Yes.
Your Lordship, here the present revision is filed under Article 227 of Constitution of India, read with Section 115 and 151 of CPC, Your Lordship. Here, Your Lordship, the petitioner is the owner of a plot of land where
Hold like this. Everything. Yes.
yes, Lordship. In the year 1985, Your Lordship, the petitioner bought a small portion of land from his ancestors, that is the Mipungsai Rui from the Oka village, for which a sale deed was executed on 9/7/1985. I'll take you that the particular annexure is annexure 1, page 27, Your Lordship. I've made a translated copy, which is page 29 of my annexure.
Is the sale deed?
Yes, Lordship. The original is at annexure 1, page 27, but then the documents which I'm showing now, it's page 29 of the annexure is the translated copy.
What is the name of the petitioner?
Nyamu Muri.
Nyamu Muri.
Yes, Lordship.
Who is the purchaser?
Lordship. May I read, Your Lordship, the translated copy, page 29.
Yes.
Sale date of land dated 9/7/1985. Ancestral lands sold by clan of Mipungshan Rui of Oka village be killed during the tenure of the names of the elders are mentioned below. And then those are the names of the elders, and then on the left side, Your Lordship, there's a land buyer, Mr. Niyamo Mori. This is the petitioner. Then after buying the land, the petitioner was enjoying till date, but then in the year
This was the ancestral land of a clan,
yes, Lordship, that is the petitioner's clan,
Nipongshan Rui.
Lordship.
Okay.
And then he bought from his ancestors, that is from the elders, that's from the same clan, which was bought on 9/7/1985 by an amount of rupees 5,000, Your Lordship.
Okay.
Then, Your Lordship, well, the petitioner was enjoying his land, Your Lordship. In the year 2021, a notification was issued by the Deputy Commissioner regarding extension of the two-lane road, Your Lordship. For that, I may take you to page 31, Your Lordship, annexure 2.
Yes.
Notification dated 5th July 2021. Notification. It is hereby notified for general information that survey for the affected building structures for damage, compensation for the work, widening of existing single intermediate road to two-lane road from kilometer 72.40 to kilometer 83.0 on National Highway 61 has been carried out by the district level verification committee. Now, therefore, the following list of affected landowners is hereby prepared and notified. Any person or party having any claims objection as per the list given below may submit in written to duties office within a period of 15 days with effect from the date of publication of this notification. Any further claims objection after the expiry of this period will not be entertained. So, through this notification, Your Lordship, some portion of my land was marked as dispute. This was the issue where it arose. So, at page 34 is that copy, Your Lordship, of my annexure, where my land has been marked as dispute, page 34. That is from serial number 187 to 192. It has been marked as dispute.
Where is your land?
187 to 192, Your Lordship. That 187, Muri, 88 also Muri, 89 Muri, and then 190 dispute, 191 dispute, 192 dispute, Your Lordship. This was the list showing my part of the land as dispute, Your Lordship, by the particular notification, while extending and widening the two-lane road at Okatong.
Okay.
So after that, Your Lordship, the petitioner reason been unknown. He filed an application before the Deputy Commissioner, that is page 35 in Annexure 3. Page 35 in Annexure 3. Annexure 3 dated on 12/7/2021 to the Deputy Commissioner Oka, subject seeking clarification in connection to notification issued by the Office of the Deputy Commissioner Oka, Nagaland, dated 5th July, published in Nagaland Post. This was the application written to the Deputy Commissioner by the petitioner, Your Lordship. And then not only that, along with this application, the petitioner is stated clearly in the point number 1. That I'm an affected landowner and the present widening of existing single intermediate road to two-lane road from kilometer 72.40 to kilometer 83.0 on NH61. That I am the absolute owner of the plot of land measuring 40 into 140 feet land bounded by west such and such. Number 3, that in the notification issued on dated 5th July 2021 Nagaland, my plot of land has been demarcated as dispute area, falling from serial 187 to 192. Therefore, I bring forward this matter, seeking clarification from your esteemed authority in regard to my plot of land with shops listed from serial 187 to 192. So that was the application submitted by me to the Deputy Commissioner. Again, since no action was taken, Your Lordship, again the petitioner again submitted another application that is at page 39 in Annexure 5.
Page
39, Annexure 5. Since the dispute was going on, this application was written to the Deputy Commissioner to put on hold payment of recurring the payment of compensation, Your Lordship. I'll just read only the subject matter. Do the TC Okanakalan subject, an application praying for rectification and inclusion of components in respect of number 187 to 192 into put on hold payment of compensation till dispute is settled. This was the second application.
Okay.
Then after a while, on that the day which the petitioner submitted the application, that is the second application, 18/11/2021. The petitioner came to know that another application was also submitted by the private respondent 4 and 5. That is, I've enclosed as Annexure 6 at page 40. The complaint written by the respondent number 4 and 5. Page 40, Annexure 6. And then the next.
In respect of the same plot of land.
Lordship.
Okay.
I've made a type copy on the next page, page 41, Your Lordship. A clear copy. Do the Deputy Commissioner Okanakalan subject complaint against serial number 187 to 192 between Oka Mukokchong Road and Church Road, Oka, for payment of 2 land road compensation, sir. With due regard, we beg to lay down the following few lines before you for your prompt action. Sir, serial number 187 to 192 belongs to Shiri L. Tongchan Rumu More Lane, but this plot of land has been earmarked in the name of other person. Therefore, we request you to help up the payment of compensation until the issue is settled amicably without dispute. Yours faithfully, Yunkosao, Mori, and party, that is the 2 private respondents which is implemented in the present revision petition. So after getting these documents, only the petitioner come to know that these 2 particular persons are trying to encroach his land, which was fought way back in the year 1985, Your Lordship. So after this, it page 42, Annexure 7, Your Lordship. The office of the Deputy Commissioner through STO Civil had written a letter to the head to Bashir. Annexure 7, page 42. Page 43 is the type copy, Your Lordship.
Yes. What is this letter?
Your Lordship, here in this letter, the head to Bashir was directed to verify and ascertain the documents, Your Lordship. This is very important, Your Lordship. I'll take you dated Oka 15 January 2022 to the head to Bashir, that is the respondent, present respondent number 3, Oka Nakalan. Subject, request to submit verification report on complaints received from affected properties or structures, owners of the ongoing 2 land road construction from kilometers such and such to such and such of National Highway 61, New National Highway 02 under Oka District. And then the last second bar. In this regard, you are directed to verify and ascertain the actual land owners of the aforementioned disputed areas and submit detailed report in this office on or before 28 January 2022. All necessary land documents agreements are to be thoroughly scrutinized before the matter is settled. This was the letter written to the head to Bashir, Lordship. And then in this particular letter, Your Lordship, the STO is clearly written only to verify and ascertain the documents, ascertain the land owners of the said dispute. That was the only direction, Your Lordship. No more, no other directions, Your Lordship. You are directed to verify and ascertain the actual land owners of the aforementioned dispute. That was the direction given to the head to Bashir. So, Your Lordship, on the basis of that, now the head to Bashir has summoned the petitioners along with the private respondents before the district customary court. The case, Annexure 8, page 44. Several summon orders were passed, but then for easy reference, I'll take you to Annexure 8, page 44. Government of Nagaland, Office of the Deputy Commissioner, District Customary Court, Oka, Nagaland. Oka, the 29 January 2022, summon order In inviting reference to your complaint in respect of ownership claim and claim for compensation with regard to affected properties or structures on the ongoing two-lane road construction of National Highway 02 with regard to serial number 187 to 192 and with reference to later number such and such, you are directed to be present in person with all the supporting documents and witnesses on 2nd February 2022 at 10:30 a.m. at the District Customary Court without fail. And then those all the summon letters were served to the parties. So after that, the petitioners and all the respondents they were presented before the District Customary Court Oka. And then their statements was taken, Your Lordship.
Okay.
Lordship, here on 6th of February 2022, they were present before the District Customary Court. Their statements were taken and recorded, Your Lordship. On 6th February 2022.
Okay.
And then here one thing is that the petitioners' witnesses were not allowed to give their statements before the court, Your Lordship. Only the respondent number 4 and 5 and their witnesses. This is important, Your Lordship.
Respondent number 4 and 5 and their witnesses.
Yes, and their witness only recorded.
But your witnesses were
They
not.
were never allowed even to enter the bushes.
Whether you produced your witnesses.
Yes, Lordship. Why? Because on this in the summon order, there was clearly given direction to bring all the documents along with if there is no witnesses. But then here, Your Lordship, the only thing is this. The STU Office of the Deputy Commissioner directed only to verify and ascertain the documents, not to conduct a court proceeding. This is illegal, Your Lordship. But for that, I'll satisfy this honorable court after my submission is over, Your Lordship, for that. After that, again on 16 February 2022, that is Annexure 12, page 62. This was the last summon order given to all the parties, Your Lordship. Page 62, Annexure 12. Page 62, Annexure 12. This was the last summon order issued to the parties before passing the impugned land dispute report.
Yes.
Your Lordship, I'll read. Dated occur the 16th February 2022, and the matter of land disputes listed in serial number 187 to 192 in the ongoing two-lane road construction. The following parties are hereby resummoned to appear before the customary court on 23rd February 2022 at 10:30 a.m. for final settlement and internal agreement or understanding between the parties, if any, may be produced to the court in writing before commencement of the proceedings. The court shall give final verdict and the matter shall be disposed of as per the findings of the court on that day. So after that, after recording their statements, Your Lordship, now on 23rd February 2022, that is the Annexure 13, page 64. This is the land dispute settlement report, which is under challenge, Your Lordship. Annexure 13, page 64. May I read, Your Lordship?
Yes.
Land dispute settlement report dated occurred the 23rd February 2022. Dispute pertaining to land listed in serial number 187 to 192 in the ongoing two-lane road construction between Shiri Nyamu More and Shiri Yankusao More, Shiri Kozamu More was summoned on 2/2/22 and resummoned on 11/2/22, but the matter could not be settled, and therefore the District Customary Court gave time till 23rd February 2022 for amicable settlement of the matter among themselves. However, since the matter could not be settled among them, the court hereby gives its verdict on the basis of its findings through spot verification and by referring to the documents exhibited to the court in the larger interest of justice. Number 1, Since the land in question measures around 228 feet in length and breadth with 39 feet, tapering at the end towards the bullish point Y junction with 5 feet. The court hereby decide that the land from within the measured area of 228 feet from Y junction till electric pole measuring 113 shall be allowed to owned by the clan of Tungchanra Mosri of Oka village. That is the respondent 4 and 5 clan. And from electric pole till the 4th steps towards Monchan's complex, measuring 115 shall continue to be owned by Shiri Nyamu Muri, that is the petitioner. Number 2, however, Shiri Nyamu Muri shall have the right to claim compensation over the structures shops within the disputed area of 228 feet. 3, other benefits other than structures, shops, Tungchanra shall be allowed to claim the right of ownership over the land. Number 4, in this regard, authority may kindly access the disputed land of 228 feet in earmark which serial of land falls within the disputed land. That in the event of non-acceptance of the verdict by the disputing parties, the right of ownership over the disputed land shall be determined through oath taking as per Lota Naka traditions, Your Lordship. This was the imbued land dispute report passed by the district court, customary court, Your Lordship. But in Your Lordship, here in the impugned order itself, serial number 2 is very confusing, Your Lordship here. However, Shiri Nyamu Muri shall have the right to claim compensation over the structure shops within the disputed area of 228 feet. That means the compensation, all the compensation, the length that is 228 feet, the length. Now, all the compensation for claiming compensation is being given to the petitioner, Your Lordship. And then again, now half part of the length you are giving to the private respondent number 4 and 5. And then as per the point 5, it clearly says that if in the event of non-acceptance of this verdict by the disputing parties, the right of ownership over the disputed land shall be determined through oath taking as per Lota Naka traditions, Your Lordship. Your Lordship, here in our state of Nagaland, Your Lordship, oath taking is a customer practices where the actual landowner will not take oath oath taking. If he is the real genuine landowner, that was the practice done in the Nagas, Your Lordship.
What is the practice? If the actual
owner, yes, Lordship. We will not take oath, Your Lordship.
Why?
No, that is the practice if he is the actual landowner. If he is the actual landowner.
If he is actual landowner, then he will not take oath.
Yes, Lordship.
That is the test.
Yes, Lordship. That is the test done since our forefathers, Your Lordship. So even the Tupashi also, if we pass order that, if they don't agree with the settlement given by the Tupashi, they will go for oath taking, Your Lordship.
No, please again explain the process.
Okay, Your Lordship, for that I've take you to paragraph 9 of my petition, Your Lordship. I've written here clearly, Your Lordship. Paragraph 9, page 8 of my petition.
Yes.
I'll read from the second part of paragraph 9, that is petitioner revisionist Nyamumuri. The petitioner revisionist stated that all the family land within the Okadan was distributed between the family members and the said plot of land was sold to him by the Mipunsan Rui descendants to him, for which the said clan had given him agreement letter sale dated 9/7/1985. As such, passing on report, he is the actual owner of the land, that is serial number such and such. He also stated that the witnesses in the sale date are still alive in is claiming the land located above the road. He further stated that if the customary oath is to be exercised, he will not take oath, but will give away his occupied land since 1985 to the respondent if they take the oath. And then on the second page, it is to be noted that oath.
No, what is meant by this? If the customary oath is
to be taken.
exercised.
Yes, Lordship. He will not take the oath because since he's been utilizing the land since 1985, and then in the year 2020 only the respondent number 4 and 5 are claiming that it's their land. So it clearly gives a general idea that the land belongs to the petitioner. So in this view, the petitioner said that if the respondent number 4 and 5 wants to take oath saying that this is his land, he is ready to surrender his land. This is the intention, Your Honor. Because the real owner is not allowed.
With 4 and 5, private respondent
Yes,
take oath
yes,
and says that
this is the land,
the,
yes,
the land belongs to them,
yes,
then he will relinquish his land
yes, Lord Worship.
without taking oath.
Yes, Lord Worship.
Why?
No, that is the old practice from our forefathers, Your Lordship. Why? Because during the early days, Your Lordship, mostly I should say they were truthful. So on that land,
So
used
whosoever takes oath,
Yes.
sanctity of oath.
Lordship.
Okay.
So it page 9 also I've stated this.
And on what basis the land settlement, land dispute settlement, this which you are challenging,
Yes, Lordship.
how the customary court decided that portion of land belongs to?
That is on the basis of the statement given by the petitioner and the respondent number 4 and 5 in their witnesses, Your Lordship. The neighbors submit any documents, Lordship. I've clearly submitted my sale date, which I've shown earlier, the year 1985 sale date. But in short, they all were in favor of respondent number 4 and 5, Your Lordship.
Okay.
So after passing that first impian order, Your Lordship, again they pass another one land dispute settlement, that is annexure 14, page 68, Your Lordship. Page 68, annexure 14. This is the partial modification of land dispute settlement, Your Lordship.
What was the modification done?
Lordship. Partial modification of land dispute settlement. Land settlement verdict which was passed by the District Customary Court Oka such and such 23rd February 2022 recorded its serial number 3, which reads as other benefits other than structure or shops. Tongchang Ramos Rui shall have the right to claim ownership over the land. Stands modified and corrected for the understanding of all concerned as under. Other benefits other than structures, shops within the allotted land of 113 feet, Tongchang Ramo shall have the right to claim ownership over the land and not the whole area of 228 feet. This was the partial modification of the earlier order, Your Lordship.
Out of 228 feet.
Yes, Lordship.
Respondent number Thangchong.
Just respondent number 4.
Respondent number 4 was
Have the right to claim
up to 113 feet.
Yes, Lordship. Why? Because earlier the total line is 228 feet. I'll take you to, you can once again do the page 64, Your Lordship. That is
No, page 64, number 1.
No, number 3, Your Lordship.
Number 1 and number 3.
They've modified the number 3, Your Lordship. Earlier, it said that other benefits other than structure shops, Tongchang Ramo Rui shall be allowed to claim the right of ownership over the land. That was the first order. And then now after modifying, now they have said that Tongchang Ramo Rui shall have the right to claim ownership over the land and not the whole area of 228 feet. That means only the 113 feet, which is allotted to the private respondent, Your Lordship.
Okay. On what basis this was decided? This land dispute settlement report, because it does not mention
Yes, Lordship.
about reasons.
Yes, Lordship. For that, I've clearly included in my blind, Your Lordship, in my petition.
On what ground you are challenging this report?
First is that, Your Lordship, the Deputy Commissioner, District Office, directed only to verify and ascertain the actual landowners, not to conduct a court proceeding, Your Lordship. And then, as Your Lordship pointed out, Your Lordship, as per the rules for administration of justice and Nakan, Your Lordship, Rule 23, it clearly lays down that the Tupasis shall try cases only forwarded by if they are forwarded by the Deputy Commissioner, Your Lordship.
So it was forwarded by the Deputy Commissioner?
No, it was just a direction given to verify and ascertain the actual landowner, Your Lordship, not the court proceeding, Your Lordship.
How to ascertain?
by Your Lordship ensured by ascertaining by submitting the documents, Your Lordship, not to take statement, Your Lordship. Because verification and court proceeding is totally different, Your Lordship. Because in the earlier which was written by the STO to the head to Bashi, you are hereby directed to ascertain and verify the actual and owners, Your Lordship. And then regarding I have also enclosed in my annexure. Your
What
Lordship.
23 provides?
23, Your Lordship. Page 79 of my annexure, Your Lordship.
Page
79, that is annexure 21. Annexure 2170, that is the front copy.
Yes.
At page 79, 23A, Your Lordship, merit.
Yes.
The Dubashis henceforward shall try and decide such civil cases only as may be referred to them by the Deputy Commissioner or additional Deputy Commissioner or assistant to the Deputy Commissioner as the case may be, Your Lordship.
So it was referred to them by.
Yes, they have referred, but in Your Lordship, I'll take you to the direct letter written by the STO. Page 43, Your Lordship. Annexure 7. The last second bar, Your Lordship. In this regard, you are directed to verify and ascertain the actual landowners of the aforementioned disputed areas and submit a detailed report in this office on or before 28 January 2022. All necessary land documents agreements are to be thoroughly scrutinized before the matter is settled, Your Lordship. This is written clearly, Your Lordship. Direction to verify and ascertain the actual landowners and to properly scrutinize their own documents blessed by the parties, Your Lordship. And then when it comes to Rule 23A, it clearly says the Dubashi can only try cases, Your Lordship, not to ascertain or verify documents, try cases only if they are being referred to them by the Deputy Commissioner or any of his subordinates, Your Lordship. That is the main ground, Your Lordship. And then suppose if the court proceeding conducted by the head Dubashi is legal, Your Lordship, then you should have allowed my witnesses to be, their statements to be recorded, Your Lordship, which clearly proves that something illegal is going on, Your Lordship. As you have said, if the court proceeding is legal as per the Rule 23A, then they should have witnessed they should have recorded my witness's statement.
What procedure should be adopted by the Bhashis while conducting cases before them?
For that, there is I have also enclosed in my annexure, Your Lordship. Page 80, Your Lordship. May I read, Your Lordship? This is the new Rule 1984 amendment. Rule 24.1 states that.
What is Rule 23?
Rule 23 is the.
Not 23A. What is 23?
23A.
Not 23A, but 23.
May I read, Your Lordship? 23 is the administration of civil justice in the state of Nagaland is entrusted to Deputy Commissioner. Page 27, Your Lordship.
Yes. Yes.
You got it, Your Lordship?
Yes, please read.
23. The administration of civil justice in the state of Nagaland is entrusted to the Deputy Commissioner, ADC, Assistant to Deputy Commissioner, customary courts constituted under Chapter 4A of the rules. Dupasis and other village authority may be appointed by the state government from time to time by notification in the official gazette, provided that the government of Nagaland shall be empowered to invest any officer or the state government having judicial experience within the powers of the Deputy Commissioner for trial of any particular civil case or cases. And the officer so invested with the powers of the Deputy Commissioner shall be designated as Deputy Commissioner and shall exercise all the powers of the Deputy Commissioner in that behalf, Your Lordship. And then on the next page, that is 23A. The Dubashis henceforward shall try and decide Such civil cases only as may be referred to them by the Deputy Commissioner or additional Deputy Commissioner or assistant to the Deputy Commissioner as the case may be, Your Lordship. And then in 23A, to decide such civil cases, it is clearly stated there, such civil cases. So for that, Your Lordship, page 31, Rule 24.1.
Yes.
In 23A, it clearly laid down that shall try and decide such civil cases, Your Lordship. So now two civil cases, Your Lordship, regarding the word civil cases, Your Lordship, it rule 24.1. May I read, Your Lordship?
Yes. Where is the requirement that with evidence may be adduced?
Yes, Lordship, for that, under Rule 24.1, it clearly lays down, Your Lordship. Every civil suit or action under this chapter shall be presented in court by filing a plaint which shall contain the following particulars, Your Lordship. A, the name of the court in which the suit or action is brought. Number B, the name and place of residence of the plaintiff. C, the name and place of residence of the defendant so far as they can be ascertained. Number D, whether the plaintiff or defendant is a minor or a person of unsound mind, a statement to that effect. E, the brief facts necessitating the filing of the suit or the action in when it arose. F, the facts showing that the court is jurisdiction. Number G, the relief which the plaintiff claims. And then at point 2, the defendant shall on a date fixed or within such time as the court may permit present a written statement of his defense. Number 3, on perusal of the plaint and the written statement filed, the court shall ascertain on what the material proposition of fact of or law the parties are at variance, and shall thereupon frame issues of fact and law of which the right decision of the case appears to be dependent, Your Lord. Yes, all are absent, Your Lordship, which was conducted by the legal proceedings conducted by the Tupashi, Your Lordship. Why? Because Rule 24, similar CBC, Your Lordship, in short, is clearly laid down the conditions, Your Lordship. But then these all were absent before the District Customary Court, Oka, Lordship.
Nobody filed any plaint.
Yes, Lordship. So now after passing the TUS impugned land dispute settlement report, where half portion of my land was given to the bribery respondent 4 and 5, I submitted another application to the Deputy Commissioner in next year 69 page, in next year 15 page 69, Your Lordship.
Yes.
This is just for withholding of the payment of compensation. And then after that, another application was submitted. Another letter was written by the EAC Sardar Oka to the head of Bashita, this in next year 16, Your Lordship. Page 70.
Yes.
Oka, the 26th April 2022, the head to Bashi, District Customary Court, Oka, Nagaland, subject. Regarding determining right of ownership over the disputed land from serial number 187 to 192 and damage compensation list through oath taking as per Lota Naka traditions. In inviting a reference to the subject cited above, I am directed to inform you that Shiri Nyamu Muri of Oka Village has submitted complaint letter dated 28 February 2022 as he is aggrieved by the verdict of the District Customary Law Court Oka issued dated 23rd February 2022 and subsequent partial modification of land dispute settlement dated 23rd February 2022. In this regard, you are hereby directed to summon both the disputing parties and determine the right of ownership over the disputed land by administering oath taking, Your Lordship, here also. Oath taking to Shirin Nyamu Muri as per Lota Naka traditions, as stated in point number 5 of the land dispute settlement report dated 23rd February 2022, and submit a report on this matter on or before 7th May 2022, Your Lordship. Since after passing the impugned land dispute settlement report, I read an application before the Deputy Commissioner. Now again, the Deputy, through the office of the Deputy Commissioner, it is the AAC, is directed the head of Bashi to Administer or taking, Your Lordship. Administer or taking.
Thereafter,
Thereafter, they were summoned on 5th May 2022, that is Annexure 17, page 72. This is the summon order where all the parties were directed to appear before customary court on 5th May 2022, Your Lordship.
yes.
Dated occurred the 28th April 2022, and the matter of land disputes settlement report by such and such dated the 23rd February 2022, listed in serial number 187 to 192 in the ongoing two-lane road construction and subsequent non-acceptance by Shiri Nyamu Muri, that is me, Your Lordship, the petitioner. The court is hereby referred by the competent authority for settlement of the dispute through swearing of oath as per traditions of the Lotas to determine the actual land owner. Therefore, the following persons are directed to appear before the customary court on 5th May 2022 at 10:30 a.m. positively, Your Lordship. But then on that particular day, Your Lordship, none of the parties take the oath, Your Lordship. None of the parties administered the oath, Your Lordship, and then oath taking was never taken, Your Lordship, before the parties. So after that, Your Lordship, after passing the said dispute report, now the Deputy Commissioner has acted upon the order state upon the state report order. Annexure 18, page 74, where I was directed to vacate the state.
With regard to the annexure 17, nothing happened.
Lordship, no. With regard to 1970, annexure 17, we all were directed to appear on 5th May 2022.
None appeared.
We appeared, but then nothing was happened. We didn't administer the
Whether
oath.
any report was again furnished to the DC.
For that, Your Lordship, documents, no documents were for that, Your Lordship. It's just that since they didn't administer the oath, now the land dispute settlement report stands.
No, by annexure 16,
Lordship.
the extra assistant commissioner instructed the Dobhashis
Lordship.
to furnish a fresh report
Yes, Lordship.
after administering oath as per Lotha traditions.
Lordship.
That was not done.
Not done, Your Lordship.
No report was furnished.
No report, Your Lordship. But in the annexure 18, Your Lordship, I think Your Lordship will be cleared, Your Lordship. This is the notice written by the Deputy Commissioner, Your Lordship.
This is also impugned by you.
Lordship, yes. Here in this particular notice, I was directed to vacate the land which was granted to the respondent number 4 and 5 by the DC, Your Lordship.
Okay.
Government of Nagaland Office of the Deputy Commissioner, occurred the 1st June 1922. 1st June 2022. Notice, whereas on the basis of findings through spot verification and by referring to documents exhibited to the court, the District Customary Court has given its verdict in the land dispute between Shiri Nyamu Muri and Shiri Yungkusau, Shiri Kuzamu Muri, through land dispute settlement report by such and such dated occurred at 23rd February 2022 and partial modification of land dispute settlement dated 23rd February 2022. And whereas due to non-acceptance of the above verdict by Shiri Nyamu Muri, the District Customary Court summoned both the parties on 5th April 2022. I think this is a mistake, Your Lordship. I think it should be 5th May 2022 as per the annexure 16. For determining the actual landowner over the disputed land as per point number 5 of the land dispute settlement report dated 23rd February 2022 through oath taking as per Lotha Naka traditions and customary practices. However, Shiri Nyamu declined to take the oath, citing his own reason. And whereas it is to be noted that construction of national highways is a time-bound exercise which must be undertaken and completed within the stipulated time frame and should not be delayed. Now, therefore, in view of the above facts and in the larger interest of the public, Shiri Nyamu Muri is hereby directed to clear, remove the standing properties, structures falling within the premises of Tungchanromo Rue Clan Lane, 113 feet. That is the private respondent's allotted land, as demarcated by the District Customary Court through land dispute settlement report dated the 23rd February 2022 and partial modification of land dispute settlement 23rd February 2022 within 15 days from the date of issue of this notice, Your Lordship. So through this, I was.
But it also says that you declined to take oath.
Yes, Your Lordship. Because, Your Lordship, since I've stated earlier, land belongs to me. I bought the land since 1985 from my forefathers, from my own clan. Documents speak itself. So he being the landowner, everybody knows of tracing the documents, but then now the respondent 4 and 5, they are claiming that they are the land. So after passing the judgments, as you have stated, oath taking was, they were directed to administer the oath, but then it was declined on the ground that since he is the landowner, he declined to take the oath. That is the reason behind the petitioner.
Then what report was furnished to DC? That report is not there.
No, not report is there. Report is not there, Your Lordship.
Then on what basis in this annexure
Since
18?
the petitioner didn't take the oath.
No, how DC has to be reported that the petitioner didn't take the oath.
Yes, Lordship.
Whether
Because-
Dobhashi's reported the matter to DC.
Yes, Lord.
Where is that letter?
Lordship, that particular document is not available with me, Your Lordship. But then,
How this court will know
Yes,
what
Lordship.
happened on that day?
Yes, Lordship, but then as far as the petitioner is concerned, his intention was that they appeared on a particular day. And then they asked the petitioner to take the oath. He declined. So case closed. So once he declines, the land disposal stands. That was the
No. You have impugned
yes,
the
Lordship.
notice dated 1st of June 2022.
Yes, Lordship.
That notice was issued on the basis of report of some Dobhashis.
Yes, Lordship.
Where is that report?
Your Lordship, the particular report is not there, but then the land dispute settlement report clearly speaks, Your Lordship.
But that was an land dispute settlement report was an earlier instance. Later on, the Dobhashis issued summons to both of you
Yes,
for
oath taking.
oath taking.
Yes, Lordship.
Then what happened during oath taking is relevant for consideration of this
Yes, Lordship.
revision petition. Whether records were called for in this case,
No, Lordship.
then you have to furnish the document. What happened?
Lordship, to be fair enough, Lordship, since they have not, the petitioner have not exhausted the Rule 31, Lordship. If Lordship may kindly come to Rule 31, Lordship. Rule 31, page 34, Lordship.
Yes,
If I'm allowed to read.
yes.
An appeal shall lie from the decision of the Majudar, Gombara, Chief, Headman, or Kales, the Bashis, or other duly recognized village authority to the tribal court, whenever constituted on otherwise, to the deputy commissioner or his assistant. A report shall be made of the matter in dispute and the decision of the village authorities, if necessary. The court shall examine the parties, and if the decision appears to be just, shall affirm and enforce it as one of its own. If the court sees reason to doubt the justice of the decision, it will try the cases de novo or refer it to the panchayat as above, Lordship. So, Lordship, here the petitioner, the revisionist petitioner, they are aggrieved by the judgment that by the decision rendered by the head Debashi, Lordship. So, Lordship, now, since they are aggrieved by that, Lordship, and they are before this honorable court,
No.
Lordship, now they have not exhausted the appeal, Lordship.
No, before that, one pertinent question is, they are aggrieved by the land dispute settlement report,
Lordship.
earlier land dispute settlement report.
Lordship.
After that, first a land dispute settlement report was issued by Dobhashis.
Debashis.
Then an amendment was done to that land dispute.
Lordship.
Some
Portion of-
clarifications was made. Thereafter, EAC wrote to Dobhashis to conduct oath takings
Yes.
that
Lordship.
as per the tradition, Oka tradition,
Lothar tradition.
Lothar tradition,
Yes.
decide the matter after administrating oath.
Yes, Lordship.
Thereafter, what happened, how the matter was conveyed to DC regarding what happened on that particular date. Thereafter, you have directly mentioned about annexure 18.
Yes, Lordship.
Annexure 18. But what was communicated to the DC? What happened during oath taking?
Yes, Lordship. Your Lordship here, yes, that particular document is not available, Your Lordship. But then here what I like to submit is that, Your Lordship. First, as you stated, I've mentioned, Your Lordship.
Because why I'm asking this question, that is the report on basis of which 1st June 22 notice was issued.
Yes.
And if that report is a reason report, you have other remedy under 32, 31
Yes, yes.
of challenging that Dobashi's order before the
Lordship.
DC's court.
Lodge.
You have not preferred that.
Lodge.
Lordship.
How you explain this?
First, regarding the Rule 31, Your Lordship. Yes, I can go for appeal before the Deputy Commissioner, but then now the Deputy Commissioner has already acted upon the order passed by the Tobashi, head Tobashi. So no way out, I have to come before this. And then this particular notice that is directing me to vacate the land, Your Lordship. So for interim, Your Lordship, I have to be before this honorable court, Your Lordship. This is the first reason, Your Lordship. Secondly, as regarding the oath taking, Your Lordship, that particular document is not here, but then the Deputy Commissioner notice clearly speaks itself that yes, direction was given to administer oath, but then they denied. It's clear written here. However, Shirin Yamamori declined to take the oath, citing his own reason. He declined to take the oath. So when he declined, automatically the head to Bashi order stands. So when the head to Bashi's order stands, the Deputy Commissioner has to act upon the order, Your Lordship. Because in the first instance, the Deputy Commissioner has clearly given direction to verify and ascertain the actual landowners. So on the basis of that, they have submitted the report. So after getting the report, now the DC has to act, Your Lordship. So I didn't file an appeal, but then since the Deputy Commissioner has already acted upon the order of the head to Bashi's order. So the petitioners know out, he has to file a civil revision petition under 227, Your Lordship. And then Article 227 can be exercised if it is shown that grave injustice has been done to a party, Your Lordship. Article 227, Your Lordship, is very clear. And then I'll submit a ruling, Your Lordship. There is a particular Supreme Court judgment, Your Lordship, where it clearly states that when an order is bad from the initial stage, Your Lordship, that particular
How this order is bad?
Lordship.
How this order is bad? This order
Because
that notice.
Yes, Lordship.
Notice as well as what you are impugning, the land dispute settlement report.
Yes.
First.
Partial modification.
Then
third, DC.
Second one is
partial modification of the land dispute.
Partial modification.
Yes.
And
Yes.
third, this DC's notice.
Yes, Lordship. And then why I'm saying that it's bad in law means, Your Lordship. First, Rule 23 is not complied. 24 one which I've shown the parties, the case name, the details, particular out of the question. Thirdly, my witnesses, if their proceedings was legal, then they should have examined and recorded my witnesses' statement also. They just recorded the private respondents' witnesses on the basis of the given judgment by granting half portion of my land to the private respondent 4 and 5.
Where is the records of Dobhashis?
Lordship, I'll take you to your Lordship.
Proceedings before Dobhashis.
Statement recorded, Your Lordship, is from page 46 in Annexure 9. But then it's written in Lota dialect, Your Lordship. I have translated and made a type copy, which starts from page 52, Your Lordship. Annexure 9, page 52, type copy of Annexure 9. Shall I proceed, Your Lordship?
No, how this court will know that you proposed to adduce evidence which was declined by the Dobhashis? Where is that proceedings?
Your Lordship, this is the only documents I got from the office, from the head of office. This was the proceedings conducted,
Proceedings in respect of what case?
that particular case. After
Case number is, what is the reference?
nothing is there, Your Lordship. They've just recorded the statement, Your Lordship, nothing. This is the only documents available from that particular head to purchase office. So that's why I'm saying that this is not as per the law. For conducting a proceeding, there are certain procedures. And then for that which I've shown, Rule 24(1), 23A should be followed.
What is the reference of proceedings before the Bashis? Which case number?
Lordship.
Nothing was reported.
Lordship, in fact, someone was issued on 28 April of 2022.
Where is the summons?
Someone which is at page 72, Lordship, annexure 17 of the petition, Lordship. And thereafter, in the summon, it's clearly stated that
Just a minute.
someone, page 72, Lordship.
Mr. Walling, you are
Lordship.
done or?
Lordship, I have one or two grounds, Lordship.
Okay, let him complete.
So after issuing the notice.
Where
again-
is the land dispute settlement report? Annexure,
Page, annexure 13, page 64. And then the other one, partial modification is annexure 14.
the reference is DDC WK/LD-1. No civil case was registered.
Lordship. This is clearly in violation of the rule 24(1)A of the rules of administration of justice in Nagaland, which I've shown. Lordship. And then secondly, 23A was not complied.
How?
Because 23A says that the Tubashi can only try cases, Your Lordship. They only try cases when hence forwarded by the Deputy Commissioner or his subordinates, Your Lordship. And then thirdly, Your Lordship, after issuing the notice against me for vacating the said particular land, Your Lordship, I wrote another application to the Deputy Commissioner also, Your Lordship. That is annexure 19, page 75. Written to the Deputy Commissioner, praying for withholding the said land dispute settlement report. Your Lordship, third paragraph, Your Lordship. May I read?
Yes.
Dated 6 June 2022 to the Deputy Commissioner Oka Nagaland. Subject an application praying for withholding notice dated 1st June 2022. That is the order which we've controlled, not just now. That however mentioned may be made herein that the said judgment of the District Customary Court Oka dated 23rd February 2022 and partial modification land dispute settlement 23rd February 2022 is based and arbitral as the said law of customary practices of the Lota Naga has not been properly followed. That therefore I request your esteemed authority to kindly hold a notice dated 21st June 2022 in the interest of the justice as the said judgment will be appealed to higher appropriate forum. This was the application. But then since the Deputy Commissioner has already acted upon the head to purchase order, now the petitioner has nowhere he has to come before this honorable court, Your Lordship. And then another document was also after passing this judgment, Your Lordship, the office of the petitioner's clan, they have issued one certificate. I've enclosed as annexure 20, Your Lordship, page 77.
Yes.
That page 77, may I read, Your Lordship? Office of the Mipunshan Rui Mori Ikung P. Kil, to whom it may concern. This is to certify that Shirin Yamo Mori Mipusang Rui of Oka Village is the absolute owner of the land located between Church Road and Mugukshong Road, Oka, Nagaland. That the said land was issued land pata by Mipushan Rui in the year 1985. Therefore, Shirin Yamo Mori has the absolute authority to utilize the land on his own will, Your Lordship. This was the certificate issued by the Mipushan clans, that is the petitioner's clan, the head of the clan, where it's clearly stated that the petitioner has been utilizing the said lane since 1985. So here, Your Lordship, my only grounds is this, Your Lordship. Since
Yes.
Since 1985, I bought the land from my elders, Your Lordship, my own claim. I've been utilizing since 1985, that is, till the issue was arose, Your Lordship, by the year 2020, Your Lordship. It was 35 years, Your Lordship. 35 years I was enjoying the particular land, Your Lordship. And then now the respondents are coming before the authority claiming the lien without any particular documents. That is one reason, Your Lordship. Secondly, which I have stated earlier, Your Lordship, rules of administration of justice, Your Lordship, Rule 23A, and then Rule 24, Your Lordship. It has not been followed. And then number 4, regarding the court proceedings conducted by the Bosches, Your Lordship, my witness statements were never recorded, which clearly states that those whole proceedings was illegal, Your Lordship. And then, as I have stated, the petitioner has been utilizing the land since 1985. Now, the private respondent number 4 and 5 are claiming the said land after 35 years. That also when the payment of compensation question came up, Your Lordship. So just for that, now they are before the.
On what basis they are claiming?
Just for claiming the compensation, Your Lordship, in short.
No, what is their ground before Dobhashis?
They are saying that it's their land, Your Lordship.
Like you said that you purchased it from the village elders of.
Yes, Lordship.
What is their
The only
basis?
ground is that, Your Lordship, they don't have any documents. First ground is that their witnesses statement. So I'm only basing on your witnesses statement, the Dubashi is given the land, half part of the land to the party.
Okay.
And then at last, I would like to place a judgment. This is 2010 SCC 677, Ritesh Tiwari and another versus State of Uttar Pradesh and another, which was decided on September 21, 2010, Your Lordship. The relevant part, page 686, Your Lordship. 686. Para 32, 33, and 34, Your Lordship. It's a very short sentence. May I continue?
Yes.
Para 32. It is settled legal proposition that if an order is bad in its inception, it does not get sanctified at a later stage. If subsequent action or development cannot validate an action which was not lawful at its inception, for the reason that the illegality strikes at the root of the order, it would be beyond the competence of any authority to validate such an order. It would be ironical to permit a person to rely upon a law in violation of which he has obtained the benefits. 33. In C. Albert Morris versus G. Jandris Kiran, this court held that a right and law exists only and only.
Referring to this judgment in what context? To impress upon what point?
Right from the initial stage. Rule was not followed.
23 was not followed.
Yes, Lordship. Yes. So if in the initial state, if it is not as per the law, even the end, it has to be quashed, Lordship.
Okay.
And then 34, this court held that if an order in the initial state is paid in law, then all further proceedings consequent to will be none as and have to be necessarily set aside. That is the principle laid down by the Apex Court of Lordship. So that concludes my.
Yes, Mr. Zimami.
No, please, the Lordship. Lordship may kindly come to the page 40, Lordship. 41 is the type of the Lordship of the petition, Lordship. Here, a complaint was received from the respondent 4 and 5, Lordship. This is a complaint letter. So basing on the complaint received by the Deputy Commissioner, then the ESC has forwarded the matter to the head GP, head Dubashi, to try the matter, Lordship. And accordingly, someone was issued.
No, before summons, summons were issued.
Lordship,
Then-
someone was issued, and thereafter, statement was recorded.
No, but the rule 24 of this rules for administration of justice and
Lordship, that has already been complied. Why? Because Lordship may kindly come to page 43, Lordship. This was forwarded by the SDO Civil Office of the Deputy Commissioner, Worka, Lordship, page 43, Lordship.
no, even if we deem this to be reference
Lordship,
of civil case,
Lordship,
then where is the plaint filed by the,
Lordship, this was a complaint that was lodged by the private respondent, Lordship. Private respondent, and accordingly, the
that complaint was
the
forwarded?
administration has acted on that, Lordship. But be that as it may, Lordship, since my learned friend, he is saying that this notice that was issued by the Deputy Commissioner, which is at page 74, Lordship, Annexure 18, Lordship. Lordship, from the reading of the said notice, Lordship, if Lordship may kindly come to the page 74, Lordship. Page 74, Annexure 18, Lordship.
Yes.
If I may allow to read, Lordship. Whereas on the basis of finding true spot verification and by referring to the documents exhibit to the court, the district customary court worker has given its verdict in the land dispute between Sri so and so and so and so.
No, but dispute has to be decided according to rules 23 and 24.
Lordship,
Merely by spot verification, you have to, what procedure is to be followed by customary court has been mentioned in the rules.
Lordship,
Rule 24 says you have to frame issues. You have to get a plaint from one party, response to that from other party. Then you have to frame issues and then decide on those issues. Nothing of that sort was done.
nothing that was done here, except a statement was recorded
And
from the face of the report.
and the petitioner was not allowed to adduce his evidence. His witnesses were not examined.
Lordship,
And no, whether any proceedings were maintained.
but rightly or wrongly, Lordship, since the Dubashi he has already passed an order, and the petitioner revisionists, they are before this honorable court challenging the said judgment and order and the modification as well as the notice issued by the Deputy Commissioner, Lordship. Rule 31 clearly states that if they are aggrieved by the order of the
No, where is the order? There is no order.
Lordship, the settlement
have-
report, Lordship.
They have
The
only
settlement report, Lordship.
issued settlement,
Settlement report.
but they
They are
have, to-
aggrieved by the settlement report.
but that report, can a civil dispute be decided by furnishing a report to DC without even customary court has to pass a judgment so that if the one party is aggrieved, they can approach DC against that judgment. This is a report to the DC
This is the report, Lordship.
where
And
no reasons are mentioned why. If you peruse this report, it only says that this much is yours, this much is yours. On what basis that was done? No reflection is there.
So in order to ascertain that, Lordship, someone order was issued to the petitioner also to appear before the before the customary court on 5 May 2022, Lordship. They appeared, but in fact they did not take the oath as per the Lotha
Whether the
tradition.
other
Lordship.
side took oath, whether the respondent number 4 and 5 took oath or not. No reflection is there. Now, as per the Lotha customary practice, how a matter is resolved, what is the process?
Lordship,
Oath will be administered.
oath will be
If
administered,
on
Lordship.
oath he says something that will be believed,
Lordship,
is it the process?
Lordship, that is the
That nobody
process.
will say or take recourse to falsity by after taking oath. So petitioner did not took oath.
Yes, Lordship.
Yes, Lordship.
Whether respondent number 4 took oath, no reflection is there.
No reflection as such, but since the petitioner is claiming that the land belongs to them, Lordship, but however, going through the court, Lordship.
No,
the
petitioner has also
purchase
purchase,
as Lordship,
also basing his claim on some documents.
Lordship, on the sale deed, Lordship.
And he says that the witnesses who were the witnesses in that sale deed are still alive. They could have been examined. Yes, anything.
Lordship, I leave it to your Lordship, since we have basing on the complaint.
Now, what has happened to that 1st June notice? Is it stayed?
Yes, Lordship.
Lordship, that has been stayed.
Order dated 23/6/2022.
Lima. Yes. Kohima. What is your name? Call the stenographer. Yes. Anything?
Lordship, that will do, Lordship.
Heard Mr. Supongwati Valing, learned counsel for the petitioner. Also heard Mr. Beto V. Zimomi, learned government advocate, appearing for respondent number 1, 2, 3. Stop. None has appeared for private respondent number 4 and 5. Stop. It appears on perusal of the records that notices were duly served on private respondent number 4 and 5 through substituted mode and by order dated 18, what is the order?
18/10/2024.
18/10/2024. This court held the notices issued to the private respondent number 4 and 5 as duly served. Stop. Therefore, this hearing was done ex parte against the said respondents. Stop. This revision petition, you may take your seats. This revision petition under Article 227 of the Constitution of India, read with section 115 and 151 of the Code of Criminal Procedure. What is Rule 29?
Your Lordship, your Rule 29, it's regarding the appeal before the Deputy Commissioner. But then since they've already acted upon it, Lordship, that particular may not be included. Article 227 will be suffice.
Civil Procedure 1908, filed by the petitioner Shri Nyamo Muri, who is impugning the land settlement report number NODCC-WKA/LD-1/2022 dated 23/2/2022 and the partial modification of the said land dispute settlement dated 23/2/2022 passed by the head Dobhashi, District Customary Court, Wokha, Nagaland. Stop. The petitioner has also impugned the notice number DCW/LR-15 within bracket BN/NH2/2020 dated 1/6/2022, passed by the Deputy Commissioner, Wokha Nagaland. The facts relevant for consideration of the instant revision petition, in brief, are that the petitioner has claimed to be the owner of a plot of land. Where is the description of the land? Owner of a plot of land which is located at Wokha town towards Police Point Y Junction. The where is the sale deed?
Lordship. Page 29. Translated. Copy.
The petitioner has claimed that plot of land and claimed that he had purchased the said plot of land by way of a sale deed from the elders of the clan of Mipong Shan Rui of Wokha village, to which the land belonged, at a consideration amount of ₹5,000 on 9/7/1985. Stop. A copy of sale deed is annexed by the petitioner in this revision petition as Annexure 1. Stop. Next panel. On 5th of July 2021, the Deputy Commissioner Wokha Nagaland issued a notification regarding the affected building / structures for damage compensation for work of widening of existing single / intermediate road to 2-lane road from kilometer 72.40 to 83.0 on National Highway number 61, and claims and objection were invited from the affected landowners. Stop. In the said notification, the list of the appended list shows at serial number 187 to 192, land of the petitioner, which has been shown as within inverted comma disputed land. Stop. On this, the petitioner approached the Deputy Commissioner Okha, Nagaland, by filing a representation on 12/7/2021, whereby the petitioner claimed that he is the absolute owner of the plot of land measuring 40 feet breadth and 140 feet length, bounded by west dash junction, east dash Monjan, MHONJN, south Church Road, north Mokokchung Road. And call for an clarification from the Deputy Commissioner in that regard. The petitioner had again also filed a representation on 18/11/2021 before the Deputy Commissioner Woka, Nagaland, praying for rectification of the list of affected persons list of affected persons, which is appended to notification dated 5th July 2021, and also prayed for putting in hold to payment of compensation in respect of serial number 180, in respect of land mentioned in serial number 187 to 192 of the said list. Thereafter, on 18/11/2021, the respondent number 4 also filed a complaint before the Deputy Commissioner Woka, wherein it was mentioned that the land mentioned at serial number 187 to 192 belongs to whom it belongs? Thungchan Romo Mure land. Who is Thungchan Romo Mure?
This is respondent number 4, Lordship.
Respondent number 4. However, this land and a request was made to held up the payment until the matter was amicably settled. Stop. Stop. Thereafter, on 15 January 2022, by a letter under reference number DCW/LR-15 within bracket B/NH2/2020, the sub-divisional officer civil, office of the Deputy Commissioner Woka, requested the head Dobhashi, Woka, Nagaland, to verify and ascertain actual landowners of the disputed areas and submit a detailed report to the Deputy Commissioner office on or before 28th January 2022. It was also directed that all necessary land documents / agreements are to be thoroughly scrutinized before the matter is settled. On receipt of the said aforesaid letter dated 15 January 2022, the head Dobhashi District Customary Court Wokha issued summons to the petitioner as well as to the respondent number 4 and 5 on 29 January 2022 to appear before the District Customary Court with all supporting documents and witnesses on 2nd of February 2022. What happened after the first summons?
After the first someone on, that is page 52, Your Lordship. The
Page?
Statements were recorded, page 52.
Statements were recorded.
Yes, Your Lordship. The petitioner, along with the two respondents and their witnesses' statements were recorded.
Stop. Thereafter, on 6th of February 2022, the statement of the petitioner Nyamo Muri was recorded along with the statement of the respondents and his witnesses. Stop. Thereafter, why summons were issued against? Again? February and annexure 12.
Just Lordship, for passing the final verdict, Your Lordship. I think in extra 62 will suffice, Your Lordship. In extra 12, page 62.
Stop. No, next, on 16th February 2022, the head Dobhashi, District Customary Court issued summons to the petitioner and respondent number 4 and 5 again to appear before the customary court on 23rd of February 2022 for final settlement of the dispute. And thereafter, on the next day, that is on 23rd February 2022, the head Dobhashi the land dispute settlement report was issued under reference number DCC-WKA/LD-1/2022 dated 23rd of February 2022, wherein it was mentioned that the matter could not be resolved amicably between the parties, and therefore the customary court has to give its verdict on the basis of the findings through spot verification and on the basis of documents exhibited before the court. It was decided as follows. Court number 1, 2, 3, 4, and 5 from page 64 of the petition. One, two, three, four, five from page 65, not 64, 65. Thereafter, on the same day, that is on 23rd to 2023, a partial modification of land dispute settlement was.
Lordship, it's 2022, Lordship, not 23. Yeah. 23 to 2022, not 23.
Yes, 23 to 2022. A partial modification of land dispute settlement was also issued by the district customary court, wherein some alterations were made in the observations made under serial number 3 of the land settlement of the lands dispute settlement report dated 23 February 2022. It is pertinent to mention herein that thereafter, on 26th April 2022, the extra assistant commissioner, within brackets Sadar Voka, wrote a letter to head Dobhashi District Customary Court, Voka, Nagaland, wherein the head Dobhashi was directed to summon the disputing parties again and determine the right of ownership over the disputed land by administering oath to only petitioner, or administering oath to the petitioner as per Lotha Naga traditions. As mentioned in point number 5 of the dispute settlement report dated 23 February 2022, and submit a report in that regard on or before 7th of May 2022. District Customary Court, Vokha, accordingly issued summons to both the parties on 28th April 2022. However, on 28th April 2022, directing the petitioner as well as respondent number 4 and 5 to appear before it on 5th of May 2022. Stop. However, on 1st of June 2022, the Deputy Commissioner, Wokha, Nagaland, issued notice under reference number DCW/LR-15B/NH2/2020 dated 1st June 2022, whereby the petitioner was directed to clear/remove the standing properties/structure falling within the premises of the Tung Chan Romo Ruiz clan land within bracket 113 feet as demarcated by District Court, District Customary Court, Wokha. Stop. Next paragraph. Mr. Supamwati Waling, learned counsel for the petitioner, has submitted that in the instant case there has been violation of the provision of rules for administration of justice and police in Nagaland, which is applicable to any proceeding before any customary court. Learned counsel for the petitioner has submitted that in the instant case, the civil rights of the parties were decided by the District Customary Court without there being any reference, without any civil case forwarded to it by the Deputy Commissioner for dispute redressal in pursuant to section 23A of the Rules for Administration of Justice and Police in Nagaland 1937. Learned counsel for the petitioner has also submitted that the mandate of Rule 24(1) of the Rules for Administration of Justice and Police 1937 was also not followed in the instant case. He submits that after the Deputy Commissioner Wokha wrote a letter, he submits that the Deputy Commissioner Wokha wrote the letter dated 15 January 2022 to the head Dobhashi Wokha only to verify and ascertain the actual landowner and submit a detailed report to it back, and no civil case was referred to it for disposal. He also submits that even if it is assumed that by letter dated 15 January 2022, dispute was referred to District Customary Court, the District Customary Court was required to follow the procedural requirement as provided under section 24 of the Rules of Administration of Rules for Administration of Justice and Police in Nagaland 1937. He submits that no plaint was filed by the respondent number 4 and 5 on whose complaint the matter was referred to the Dobhashis to the District Customary Court. He also submits that neither any issues were neither any opportunity was granted to the petitioner to file written statement in his defense, nor any issues were framed in this case. He further submits that even the petitioner was not allowed to adduce evidence of his witnesses. Stop. He therefore submits that what else is your submission?
Since 1985, Your Worship, for 35 years, the petitioner is enjoying the lane, but only in the year 2021.
He also submits that after purchase of the land in the question in the year 1985, the petitioner is in possession of the said land. Stop. He submits that in this case, the reference made to Dobhashis, reference made to District Customary Court and proceedings of the proceedings before the District Customary Court were not in accordance with the rules for administration of justice and police in Nagaland 1987. Hence, the impugned, hence he prays that the impugned where is that report? Impugned land dispute settlement report dated 23rd February 2022, comma, the modification
6-8.
H
6-8.
the partial modification of the said land dispute settlement on 23rd February 2022, as well as the notice issued by the Deputy Commissioner on page
74.
on page notice issued by Deputy Commissioner on 1st of January 2022.
What's the first of John, Lordship?
1st of June 2022 may be set aside. It has to be decided afresh. Suppose if we set aside it,
Lordship.
it has to be referred back.
Yes, Lordship, opportunity will be given, liberty will be given to file before competent court by filling appropriate suit for declaration, Lordship. That will,
No, that has, you can file.
Lordship.
Stop. On the other hand, Mr. V. Zimobi, learned government advocate appearing for the state respondent, has opposed the prayer, may oppose the submissions made by learned counsel for the petitioner, and has submitted that in this case, the dispute was referred to the customary court Vokha by the SDO Civil Vokha by letter dated 15th January 2022 in pursuant to the mandate of section 23A of the Rules for Administration of Justice and Police in Nagaland. Stop. He submits that both the parties were afforded sufficient opportunity to adduce evidence in support of their case. However, he also submits that the petitioner was given or was afforded opportunity to take oath in accordance with the tradition of Lotha community. Lotha community, but he failed Lotha Naga traditions and customary practice. However,